Good day. I'm Jeff Clayton. I'm Executive Director of the American Bail Coalition. Thanks for taking the time to watch our series 2021, an update on bail reform. In this final module 4, we talk about the effectiveness in bail setting. We cover a variety of topics, including calibration of the system to use bail and personal recognizance bonds when appropriate, use of unsecured bonds, data collection, supervision, and bail schedules. Boy, that's a lot to get into. We better jump right in. To begin, private surety bonding agents are licensed in 46 states, and I would point out they continue the tradition of our personal surety system in the United States of America by acting as a compensated personal surety by posting a financial guarantee, a bond for a defendant. The so-called cash bail system is a creation of statute, and surety bonding agents are not allowed to post cash bails. So it's important at the top to realize surety bonding agents post a financial guarantee. They do not post cash. They post a financial guarantee for a defendant. As part of being involved in the personal surety system, custody is transferred from the state to the licensed bail bonding agent, who then has the power to arrest the defendant. The arrest powers of the surety bail agent deter defendants from fleeing and often from committing new crimes because the agent has the power to revoke the bond prior to trial and rearrest the defendant. And this power to revoke bond flows from third parties. Third parties also can request revocation of bonds under various circumstances. Third parties are the ones that typically post bail for defendants, and they are parties to the bail contracts. They are the ones who stand to lose if the defendant doesn't do what they are supposed to do and the bond is forfeited. Third parties have a strong incentive to make sure that the defendant appears and does not commit a new crime. And often we've heard over the years that when a person goes on a crime spree or a drug-induced binge and committing a bunch of crimes, that co-signers will call and revoke bond. Third parties are on the hook for forfeitures, and they'll typically monitor defendants to make sure that they're doing what they're supposed to be doing because they don't want to risk, forfeiting the entire bond. Third parties will also work with bail agents to track down defendants who abscond. So this playing the role of the personal surety is a very important distinction in this concept of the quote-unquote cash bail system. Let's talk about the effectiveness of bail just briefly. According to the U.S. Department of Justice, Bureau of Justice Statistics, in a 2007 study, quote, compared to release on recognizance, defendants on financial release were more likely to make all scheduled court appearances. Defendants released on an unsecured bond or as part of an emergency release were most likely to have a bench warrant issued because they failed to appear in court. This study looked at data from 75 of the largest jurisdictions in the United States. And while it did not control for whether somebody was on pretrial release or not, it did show that defendants on financial release were more likely to make all scheduled court appearances than release on own recognizance bail. Also, cash bail reform has been shown to increase crime in both New York and Illinois. Dermot Shea, the commissioner of the New York City Police Department, has said that bail reform led to an increase in crime. In a 2020 study from the University of Utah School of Law found as follows, quote, this article explains that contrary to the study's assertions, the new changes to pretrial release procedures appear to have led to a substantial increase in crimes committed by pretrial releasees in Cook County, Illinois. Properly measured and estimated, after more generous release procedures were put in place, the number of released defendants charged with committing new crimes increased by 45%. And more concerning, the number of pretrial releasees charged with committing new violent crimes increased by an estimated 33%. So, the alternative to the current system has been shown to increase crime. That is important for policymakers to realize. Professor Alex Tabarrok of George Mason University explained in 2019 that those who are detained on bail are twice as dangerous than those who actually post bail and get released. Those who do not post bail, quote, have twice as many arrests and twice as many convictions. For example, the average defendant who doesn't make bail has 6 previous felony arrests and 4 previous fails to appear. 4 previous failures to appear, the average. And so to argue that bail does not protect public safety doesn't make sense. Those who stay in jail are twice as dangerous as those who are released. That's important for policymakers to realize. Professor Tabarrok also noted that his peer-reviewed research made findings that bail agents play a valuable role and a quantifiable role in the system. Quote, the bounty hunters are really the long arm of the law. And my colleague and I found that people who are released on commercial bail are 28% more likely to show up. And if they fail to show up, they're 50% more likely to be caught quickly and not be at large within a year. And as I always tell people, while they may not go on to commit a new crime within the jurisdiction, that the statistics would show when they've gone on to be at large and move to another jurisdiction, they're committing crimes that the system doesn't pick up, that bail agents stop by getting them back to court more quickly. Dr. Robert Morris studied the Dallas County system and issued two different studies, but he found as follows, quote, as to the costs associated with failures to appear across each release type, model estimates suggest that commercial bond releases were the most cost effective in Dallas County, based on the group of defendants captured by the study. This finding was corroborated by the observed data, which suggested that for the 22,000 plus defendants captured in the study, assuming a public cost of $1,775 per FTA, the use of commercial bonds saved over $7.6 million among felony defendants and over $3.5 million amongst misdemeanor defendants, as compared to attorney bonds, cash bonds, and pretrial services bonds. Dr. Morris also studied the San Francisco system in 2018 and found that surety bonds had the lowest failure to appear rate of any form of release. Release on bail had a 20.6 failure to appear rate, while court release on own recognizance had a 61.9% failure to appear rate, and a supervised release had a 62.9% failure to appear rate. To add to this, interestingly, releases on bail occurred in a matter of hours, whereas these other releases, which were ineffective, took several days to process through the court system. The next topic we need to discuss is an unsecured bond. These are a joke bond because somebody promises to pay a forfeiture if they don't show up. Well, when they don't show up, they don't later show up to pay. In fact, unsecured bonds are no more effective than forcing a defendant to simply sign a promise to appear, according to the U.S. Department of Justice Bureau of Justice Statistics study in 2007 that I referred to. In addition, unsecured bonds are dishonest with victims and the public because jurisdictions seldom collect them. They are a letter to God in the purest sense. And to say that somebody was released on a bond when in fact they have to secure nothing makes no sense. That doesn't mean, as we've said, that somebody should have to post 100% cash. Posting a financial guarantee that it is 100% secured is much more effective than unsecured bonds. Partially secured bonds, unsecured bonds, they don't work. There's no reason to do them. People should either secure their bond or they should get a release on their own recognizance. The next topic I think we need to talk about is litigation over the use of cash bond proceeds by courts, whether by collecting 10% of a bond and putting it in court coffers, or by keeping all of the cash bond proceeds and then reallocating them. One federal court held that keeping cash bail deposits is unconstitutional insofar as collections is not a purpose of bail. And there's, of course, a split of authority on this in the circuits, with another determining factor whether the term of the bond itself requires forfeiture, which has also been held unconstitutional in one circuit. The judges in New Orleans were able to allocate forfeited bail proceeds directly to their own offices and staff, which was held in unconstitutional conflict of interest because they had an interest in setting higher bonds, which got forfeited, which then led to nicer offices, nicer chairs, and better copy machines. Studies that conclude that posting financial conditions do not increase public safety presume falsely that some other system or reform will increase public safety, when there's really simply no evidence to prove that. There's no peer-reviewed studies that have come out that suggest that pretrial services, pretrial supervision, or as we'll learn later, that preventative detention is going to decrease crime. There's no peer-reviewed studies that suggest that unsecured bonds will increase public safety over the existing system. There has been a widely spread study that comes out of Jefferson County, Colorado, but that study was never peer-reviewed. It applies only to Colorado, and it's been debunked by several commentators. But let's look at what the Arnold Foundation recently said about, and in terms of the effectiveness of pretrial supervision. They made the following statements. One, quote, pretrial monitoring does not appear to reduce pretrial arrests, unquote. Two, quote, there is no clear association between location monitoring and improved pretrial outcomes, unquote. And three, quote, there is no clear association between drug testing and improved pretrial outcomes, unquote. In other words, the whole concept that we need to steer people to alternatives is not proven to be a more safe, effective alternative. So if the argument is pretrial safety, let's take a look at it. If the argument is reducing FTAs, let's take a look at it, because the data does not back up the fact that the alternate system is more effective. And so to say that bail does not protect public safety presumes there's a better alternative, when in fact there is not. Regarding data collection, I would argue that who is in jail and why is an important consideration, as Professor Tabarek's research indicated. And second, data should be collected regarding the results of the system. The true benefit cost analysis, like the Morris study, should be conducted, because every time a defendant fails to appear in court, that costs the system precious resources that could be applied to other purposes. Regarding bail schedules, we discussed the legal issue, I think, in more detail in the first module. But if judges are going to set a bail schedule, they should look at data and trends to try to isolate specific defendants, charges, or even circumstances where courts are seeing high failure to appear rates or high new crime rates. It is counterintuitive, but the severity of the charge is usually not an indicator of risk of failing to appear and risk to commit a new crime on its own. And typically lower level charges indeed will have higher failure to appear rates, which is counterintuitive, but is important for judges to keep in mind that you may actually end up doing more bail in some of these lower level cases than you would in some of these higher level cases where the failure to appear rate would be lower. Finally, I would want to point out that we're not against sensible bail reforms that addressed issues within the criminal justice system. It's not bail that drives many of the issues in the pretrial process. And we think other reforms than bail also need to be looked at. Our method has always been to look at each bail system, whether it's statewide or countywide or citywide, to diagnose the problems and to find specific solutions to the problems within each of those jurisdictions. And as part of that, we've created what's called the fourth generation of bail reform in America, which keeps the tradition of the personal surety system alive, but I think recognizes that modernizing and focusing on the system can achieve substantial results. And we think our fourth generation of bail reform is important for that reason. If you have questions, visit our website. Send me an email at jclayton@americanbail.org. This generation of mass incarcerations really started around 1970, and we have a lot of digging to do to kind of figure out what the causes were. But on the bail side, I think the movement toward risk-based preventative detention has proven to be a problem. Our fourth generation of bail reform, I think, takes us back to a reasonable personal surety system, takes things like collections of revenue out of the system as a reason for granting bail, and really makes a more sensical system that we think protects both the rights of the people to prosecute defendants and the defendants' rights to be at liberty pending trial and their right to the presumption of innocence. Thanks again for taking the time to watch our series in this final module. Again, we thank you for your time and wish you a good day.